Stop scrolling, because what you're about to hear isn't gossip, it isn't speculation, it isn't a rumor from some anonymous social media account. This is a move, a deliberate decision, and a document that could redefine everything for Prince Harry. And if you want to understand how the future of the Sussexes is quietly being decided, make sure you watch this entire breakdown and subscribe now. When this story breaks publicly, you'll want to know you were here first before anyone else. It usually starts with a whisper, a fleeting rumor, a blurry photo, a casual remark. But this time, it didn't start quietly. It started with action. In January, Meghan Markle quietly rehired Sunshine Sachs. To most people, that's just another Hollywood PR firm. But in the world of celebrity power plays, Sunshine Sachs is the kind of firm you hire when you're preparing for a seismic event, a divorce, a high-stakes settlement, or a public narrative designed to control the fallout before it even happens. For months, the public has been observing the Sussexes with a mix of fascination and concern. Separate business ventures, solo brand launches, awkward public appearances that lack warmth. And yet, while the headlines focused on Spotify cancellations, Netflix downgrades, or Instagram campaigns gone wrong, something far more consequential was happening behind closed doors. The rehiring of Sunshine Sachs was not defensive, it was a signal. In Hollywood, crisis management doesn't wait until the explosion. It's orchestrated months in advance, every detail calculated to frame the story on your terms. Why now, and why does veteran royal biographer Tom Bower warn that Prince Harry is walking into a trap he cannot see? The answer is hidden in plain sight. A legal document, signed years ago, amended during one of the most chaotic periods of their lives, contains a single clause that changes everything: control of money, assets, and future ventures. This isn't an idle footnote, it's a blueprint, and Harry may be unaware he signed away far more than he ever imagined. Tom Bower isn't a tabloid writer chasing clicks. He is a former barrister and BBC journalist who has spent 4 decades dismantling the reputations of billionaires, tycoons, and public figures who thought they were untouchable. He doesn't rely on unnamed sources or insiders. He interviews lawyers, accountants, palace staff, and executives. He reconstructs financial transactions. He verifies every fact before publishing. For his investigation into the Sussex marriage, Bower conducted over 80 interviews, spoke to palace staff, Hollywood agents, and legal minds who know the intricacies of the Sussex finances. When Bower describes a poison pill in their marriage agreement, he isn't guessing, he is reporting. What he uncovered disrupts the narrative of a united, romantic partnership. While Harry believed he was navigating the world as a protector, the prenup amendment quietly redefined the rules. It shifted power, income, and ownership into structures where Meghan, as the primary manager of their ventures, retains the controlling stake. In legal terms, it's a masterstroke. The future profits of joint projects, intellectual property rights, and brand identity are tied to the person who manages the business. And according to Bower, in nearly every instance, that person is Meghan, not Harry. This isn't speculation, it's law. Harry may have thought he was negotiating freedom when he signed documents during the chaos of Brexit. Emotional, angry, desperate to escape the UK, he trusted the process. He believed they were equals in a partnership. But the legal language, drafted with precision, categorized him as talent, replaceable, dependent, and outside the center of control. Meghan became the producer, the manager, the one who owns the stage and the rights to the story. And this legal architecture intersects with real-world consequences. Their move to California placed them in a community property state, where assets accumulated during marriage are typically split 50-50. But the amendment on page 14 doesn't just alter a 50-50 split. It redefines ownership in a way that favors managerial control over earned contribution. Harry may be at risk of losing not just income, but control of his story, his memoirs, and future projects tied to his personal brand. Even more troubling, the timing. The document amendment reportedly took place in 2020 amid the upheaval of their departure from royal duties. Palace legal support was absent. Harry was emotionally vulnerable. He signed away power under the guise of establishing a new life in America. What seemed like a bureaucratic formality was actually a strategic shift, quietly setting the stage for what may come next. Financial leverage, narrative dominance, and legal control that is almost entirely in Meghan's hands. As of now, Harry is still the public-facing figure, the prince bearing the heat, the criticism, and the scrutiny, while the true legal leverage remains largely invisible to him. Sunshine Sachs' involvement signals that Meghan is planning the story before the papers hit the desk, shaping the narrative to her advantage. Every detail, every timing, every subtle public move has been orchestrated to protect her interests while limiting Harry's options. The question now is whether trouble exists. It's whether Harry can even recognize the trap he may already be inside. The whispers of estrangement, the separate business ventures, the subtle distancing. These are all pieces of a puzzle that, when assembled, show a meticulous, premeditated strategy. And the key, according to Tom Bower, lies in the document, the amendment, and the clause that quietly transferred managerial control from husband to wife. Harry may still think the battle is external, against press criticism or palace scrutiny. But the real war has been quietly fought in legal language, trust, and timing. And if Bower is correct, the battle has already been decided. The fairy tale isn't ending because of scandal. It's ending because the rules of engagement were quietly rewritten years ago, and Harry may not even know it yet. The story doesn't unfold in headlines or Instagram posts. It unfolds in documents, clauses, and the fine print that most people ignore. And according to Tom Bower, the document at the center of the Sussex marriage isn't just paperwork. It's a blueprint that redefines power, control, and income. For Prince Harry, the implications are profound. What looks like a fair settlement or a simple business arrangement is anything but. It is a carefully engineered shift, one that places the real leverage squarely in Meghan Markle's hands. To understand why this is so significant, we need to start with context. In the United Kingdom, royal prenups are designed to protect the crown. They ensure that ancestral estates, jewelry, and titles remain untouchable, regardless of marital discord. Most royals enter marriage with legal armor. But Harry and Meghan made a choice. They moved to California. That decision, at first glance, may have seemed like a fresh start, an opportunity to step away from the rigidities of palace life. In reality, it placed them under a very different legal framework. One where the rules favor equality on paper, but manipulation of legal structures can tilt the scales. California is a community property state. That means that, generally, anything earned or acquired during the marriage is considered jointly owned and would be divided 50-50 in the event of divorce. The Netflix deal, the book advances, the Montecito mansion, all potentially subject to shared ownership. But Bower's investigation reveals that the amendment in 2020, buried quietly, signed during emotional upheaval, contains a clause that overrides this baseline. It doesn't just speak to money. It speaks to control, management, and future revenue, particularly regarding intellectual property. And that clause, reportedly on page 14, favors Meghan in ways Harry may not fully comprehend. The language of the clause is precise. It defines the primary manager of any joint venture as the individual with ultimate control over the business entity, intellectual property, and brand assets. That person, according to nearly every record Bower examined, is Meghan. She is listed first on trademarks, first in corporate documents, and first on public-facing brand materials. Harry, under this legal definition, is categorized as the talent, the face, the performer, the individual who generates the content but lacks managerial control. In Hollywood terms, talent is replaceable. The producer, the manager, the person controlling the entity owns the rights. The amendment effectively recasts the marriage as a professional partnership where Meghan is the owner and Harry is the star. The consequences are wide-ranging. Harry's memoir, Spare, his book advances, and any related intellectual property fall under the same framework. Even though he authored the content, the corporate structure and the page 14 clause suggest that managerial control, and thus potential future revenue, resides with Meghan. In other words, the financial and creative benefits of his labor may not fully belong to him if the marriage dissolves. It's a reality that turns conventional expectations upside down. Bower's reporting indicates that this wasn't an accident. The 2020 amendment coincided with Megxit, a period of intense upheaval. Harry was emotionally raw, angry at the palace, and desperate to establish independence in America. He signed documents that he believed were part of a necessary restructuring for a new life, without the meticulous scrutiny that a prince would usually apply under palace legal oversight. What he thought was a step toward freedom, in legal terms, became a transfer of power. The primary manager clause redefined their joint ventures, tipping control toward the partner who handled the administration, Meghan. This dynamic also interacts with broader financial mechanics. California law may provide baseline equality, but corporate structures, trusts, and intellectual property law allow for deviations that favor one partner over another. By aligning managerial authority with her name, Meghan secured not only control over current assets, but leverage over any future earnings. It is a masterstroke in legal foresight. The moment of signature, the choice of jurisdiction, and the precise drafting all combine to give her a disproportionate level of security. Even their most publicized deals are caught in this web. Netflix, Spotify, and other ventures were structured through shared entities. While headlines shouted about multi-million-dollar deals, Bauer's sources suggest that much of that income is funneled through accounts and entities where Meghan holds the controlling interest. The cash flow may appear joint, but control, the true power in any negotiation, rests with her. This is especially consequential if disputes arise, as courts often defer to the managerial designation outlined in corporate governance documents. Beyond money, the clause also establishes precedent for brand ownership and intellectual property. Harry may think of himself as the public face of the Sussex brand, but legally, the manager defines the brand's future. Merchandising, media projects, speaking engagements, they are all entangled in the framework established by page 14. It is the silent leverage that could dictate terms in a divorce long before lawyers begin negotiating settlements. What Bauer paints is a picture of strategic patience. Meghan's moves, from rehiring Sunshine Sachs to structuring new ventures under her management, are consistent with a blueprint she has executed before. This is not reactive. This is preparatory. Every business decision, every corporate filing, every PR narrative aligns with a legal structure that maximizes her security and minimizes Harry's options. The page 14 clause in this context isn't just a document. It's a lever, a tool, and potentially a weapon. And the tragedy from Harry's perspective is that it is invisible until triggered. On the surface, he continues to act as the head of the household, the public-facing figure, the prince bearing scrutiny and expectations. But underneath, the rules of engagement have been quietly rewritten. He is no longer negotiating as an equal. He is negotiating from a position that was quietly diminished the day he signed that amendment. And if Bauer is correct, the ramifications extend far beyond money. They touch control, narrative, and the very story of his life. The question now is not about intent. It is not about emotion. It is about understanding the structure of power. California law, corporate governance, and the page 14 clause have combined to create a reality that may already define the outcome. And if Harry is unaware of the scope, he may be walking directly into a situation where legal leverage, narrative control, and financial security are no longer in his hands, but in hers. The fairy tale, it seems, is increasingly being defined by documents, not headlines. The battle for control isn't fought in headlines. It's fought in patterns, in behavior, and in the small, seemingly mundane decisions that compound into an insurmountable advantage. And according to Tom Bauer, the Sussex marriage exhibits those patterns with alarming clarity. The legal architecture we discussed in Part 2 doesn't exist in isolation. It interacts with finances, lifestyle decisions, and social dynamics in a way that increasingly isolates Prince Harry and concentrates leverage with Meghan Markle. Start with the finances. Public narratives focus on Netflix deals, Spotify agreements, or book advances. Headlines boast tens of millions, but insiders point out that these numbers were ceilings, not guaranteed payments. Initial payouts may have been used to fund a lavish lifestyle, security teams, private jets, Montecito estate maintenance, PR retainers, and personal staff. That cash is evaporating at an unprecedented rate. Meanwhile, the structure of joint entities and trusts reportedly ensures that the controlling managerial partner, Meghan, maintains authority over remaining assets. Harry may be earning and spending, but the real legal power over the assets is slipping further from his hands. Isolation is another critical element. Divorce experts refer to it as the strategic isolation of a partner. Once a spouse is cut off from their historical support system, friends, family, advisors, their ability to negotiate effectively diminishes. For Harry, this appears to be happening systematically. Old friends from Eton and the military have been largely sidelined. Wedding ushers, longtime confidants, and colleagues have reportedly been distanced after questioning the speed or dynamics of the relationship. Even familial communication with William and Charles is strained, leaving him untethered in a country where he has no lifelong support network. This isolation intersects directly with legal and financial leverage. A spouse who is emotionally and socially isolated becomes increasingly dependent on the partner who controls resources, narrative, and access. Harry is reportedly living in a private bungalow or hotel, away from the Montecito estate for stretches of time. While publicly it may appear that Meghan and Harry are merely pursuing separate routines, the effect is subtle but profound. She is consolidating control over the household, the narrative, and the financial ecosystem, while he becomes increasingly reactive rather than proactive. Historical patterns reinforce this trajectory. Meghan's previous divorce from Trevor Engelson is instructive. According to Bauer's sources, that divorce was swift, efficient, and heavily managed. Meghan reportedly established a separate life, moved physically and socially away from her spouse, and ensured a clean financial separation that maximized her independence. Friends described her approach as meticulous and unflinching. No asset was left unsecured, no narrative uncontrolled. For those studying the Sussex marriage, the parallels are striking. Solo ventures, new trademarks, and targeted PR moves suggest a repeat of a strategy she has successfully executed before. The PR moves themselves are highly calculated. Sunshine Sachs rehiring is more than a signal. It is a tool for narrative engineering. In Hollywood divorces, public perception is as critical as legal leverage. By shaping the story months in advance, stories of separation, growing apart, mental health struggles, and personal evolution, Meghan can preemptively frame public opinion. If or when the divorce occurs, she isn't merely negotiating in court. She is negotiating in the court of public perception, where reputation and brand value carry measurable financial weight. Childcare and custody further complicate the landscape. California law favors the primary caregiver in custody disputes. Archie and Lilibet are enrolled in local schools, have established medical care, and reside permanently in the state. Any attempt by Harry to relocate them to the UK would require Meghan's consent, which, according to sources, is unlikely. The legal structure, combined with physical logistics, creates a situation in which he is tethered to a jurisdiction that favors her, while simultaneously being emotionally isolated and socially constrained. This effectively anchors him, reinforcing the leverage she holds. Even social optics play a role. Public appearances, interviews, and philanthropic projects reinforce Meghan's narrative of independence, competence, and strategic foresight, while Harry is often depicted as reactive, reflective, and nostalgic for lost connections. This narrative contrast, whether intentional or incidental, strengthens the perception of a power imbalance, which in turn can influence legal and financial negotiations. Judges and mediators, while impartial, are not immune to the reality of one partner, actively controlling the flow of information, resources, and logistics. The financial patterns, behavioral strategies, and social isolation are not accidental. They form a coherent system. Sunshine Sachs, legal amendments, California jurisdiction, and public-facing ventures all converge to create a framework in which Meghan holds control. Every solo project, from ARO to her podcast deals, is a safeguard, a lifeboat that ensures she can operate independently. Even the Montecito estate, often portrayed as a marital home, is structured in ways that provide her long-term leverage, both financially and strategically. The psychological impact on Harry is significant. Isolation, combined with the knowledge that assets and legal control may already favor his spouse, creates a vulnerability that can influence decisions, negotiations, and public behavior. Bauer's sources describe a man who is increasingly focused on the past, on grievances, and on legal battles in the UK, while the present, the structure of control around him in California, is quietly consolidating in Meghan's favor. Now the stakes go far beyond money, PR, or personal brand. The true fulcrum of this potential divorce rests on the one element no negotiation can ignore: the children. Archie and Lilibet, the next generation of the Sussex line, are at the center of a legal and emotional battlefield that will define Harry's options, his freedom, and his future as a father. And when you combine California law, international custody rules, and the managerial leverage established in the page 14 clause, the picture is stark. Harry is navigating a terrain where every move is constrained, every decision scrutinized, and every misstep amplified. California law dictates that the best interest of the child governs custody decisions. It is not a guideline, it is the controlling standard. Habitual residence, access to schooling, healthcare, and community all influence judges' determinations. Archie and Lilibet are embedded in California. They go to school there, receive healthcare there, and have social ties there. Any attempt to relocate them, whether back to the UK or elsewhere, requires consent or a court ruling that is unlikely to favor unilateral action by Harry. This is not speculation, it is precedent. Judges in California routinely prioritize stability, continuity, and the primary caregiver's decisions over nostalgic or royal considerations. This legal framework intersects with the personal and psychological dimensions Bauer highlights. Harry is reportedly emotionally tethered to his children. He has publicly expressed a desire to maintain close bonds and provide stability. That very devotion under the California custody system places him in a vulnerable position. The parent most closely associated with day-to-day management, in this case, Meghan, holds leverage. If Harry attempts to assert control beyond what the court deems reasonable, he risks not only legal pushback, but also a narrative that casts him as obstructive, reactive, or even unstable. Every misstep can be leveraged against him, both legally and publicly. Titles and branding introduce an equally high-stakes layer. Unlike financial assets, titles and honorifics carry prestige, social capital, and commercial value. For Meghan, the Duchess of Sussex title is not merely ceremonial, it is a brand. It commands speaking fees, invitations to elite circles, and global recognition. Losing it would undermine the empire she is meticulously building. Bauer reports that sources indicate the title is a non-negotiable red line. She will fight fiercely to retain it, leveraging legal precedent from other royal divorces. Sarah Ferguson remained Duchess of York. Diana retained the Princess of Wales style, even after losing HRH privileges. Meghan is aware of these precedents and appears prepared to follow them to their logical conclusion. Harry, by contrast, was born a prince. His status is immutable, anchored by bloodline rather than brand. He does not need the title to operate socially or professionally. This asymmetry fundamentally changes the power dynamic. Meghan's fight is existential in a branding sense. Harry's is symbolic and personal. When financial, social, and emotional stakes intersect with titles, the scales tilt toward the partner who has the most to lose, in this case, Meghan. She is methodical, strategic, and legally savvy, while Harry continues to navigate reactive, emotion-driven decisions. Timing is critical. Bauer's investigation highlights the rehiring of Sunshine Sachs in January as a signal of a deliberate rollout plan. Celebrity divorces do not happen overnight. They are months, sometimes years, in the making. Sunshine Sachs is not hired to respond to a filing. They are hired to craft narrative arcs, control leaks, and prepare public opinion. According to industry insiders, the 6 to 12-month timeline suggests that by early 2026, the narrative will be fully constructed. Harry as the troubled, nostalgic, sometimes isolated prince. Meghan as the proactive, independent, future-focused mother and businesswoman. The public story is being framed even before legal proceedings officially commence. The convergence of these elements, legal leverage via page 14, managerial control over assets, California custody law, strategic isolation, and brand preservation, paints a chilling picture. Harry's public persona, the prince carrying the weight of history, is effectively constrained by structures he may not fully appreciate. The legal battlefield has been quietly laid out over years, with each document, signature, and business decision acting as a reinforcing mechanism. The psychological dimension is equally significant. Isolation, Emotional vulnerability and the pressure of public scrutiny create a perfect storm. Harry may feel trapped, frustrated, or powerless, but the reality is that his options are being shaped not by emotion alone, but by pre-existing legal and financial architecture. Every conversation, every decision, and every negotiation is filtered through the structures that were quietly established long before he realized their implications. Bauer's conclusion is stark. The fairy tale is over, but the legal thriller is just beginning. Money, assets, and titles are critical, but the ultimate leverage rests in the combination of custody, managerial control, and narrative dominance. When the divorce filings occur, when PR campaigns roll out, and when public perception crystallizes, Harry may discover that the most critical battle, control of his children, his brand, and his story, has already been preemptively contested and strategically structured against him. The final act, according to Bauer, will not just be about separation. It will be about leverage, about who defines the narrative, controls the assets, and shapes the future. Harry may be blindsided, or he may have counter-strategies of his own. What is undeniable is that the groundwork, meticulously laid through legal, financial, and strategic channels, positions Meghan in a place of extraordinary advantage. And the question that remains for everyone watching is whether Harry can navigate his way out, or whether the legal and narrative structures now surrounding him are already insurmountable. The Sussex saga, it seems, is no longer just a story of romance, rebellion, or media fascination. It is a high-stakes legal, financial, and social chess game, one where every move has been calculated in advance, and where the endgame is being quietly defined while the world watches only the surface.